We're with Adam Feldman. Adam is a criminal defense attorney in Phoenix, Arizona. He's agreed to answer some online questions related to drug crimes and drug offenses. With that said, Adam, let's go into our first question. How many drug cases have you tried and won?
It's a tough question. Most criminal defense attorneys don't keep track of the trials that they've done and won. And if they can give you a number, it probably means that they haven't won that many. Over the years, you should be winning a ton of these cases. So the answer is a lot. And I'll take that even a step further. The safest way to win a case is not to win it in trial, because ultimately, if you're taking a case to trial, you are leaving the decision as to whether it's somebody's freedom, as to whether it's a felony on somebody's record. You're leaving those decisions to 8 members of a jury or 12 members of a jury, depending on the charges. So one of the other things I pride myself on, in addition to my ability to win at trial, is my ability to win before trial. And that is always the safest thing. So specifically with drug cases, you want to work something out where you can get the case dismissed before trial. And if you can do that, that is a bigger success than winning at trial. And when it comes to getting drug charges dismissed or dropped before a trial or with nothing on somebody's record, I have done that countless numbers of times where people have come to me with these very serious drug charges where they're looking at huge fines, they're looking at permanent felonies on their record, and we've created situations where all of a sudden they just have to take a few classes, maybe drop some drug tests, and everything goes away. So I hope that answers your question.
Okay, excellent. The next question is very specific. My son received a drug possession charge, and we're looking to hire an attorney. What can be done to keep this off his record? He is a college student.
All right. You're finding yourself in a situation where a lot of college students or parents of college students are finding themselves. Child goes off to college and they're having fun, oftentimes a little too much fun. Next thing you know, they end up with these drug possession charges. Drug possession charges, they are some of the most successful cases that we have here because you can relate to it, unless we're talking about a college student who is running a drug selling operation out of his dorm room. That's far more serious. But if you're talking about a typical college student who is sampling with drugs and gets caught, we're very successful in getting those cases ultimately dropped. Typically, we can coordinate with the prosecutor or with the detectives, work out something where through the use of or through going into classes or community service, maybe with some drug testing to ensure that your child is clean, that all charges can be dropped. You can never guarantee this, hey, with every case this is going to happen, but over the course of the years, I have seen tremendous success rates with getting these young students clearing their record of these drug possession charges.
Okay, next question we had is, my husband is in Maricopa County for a distribution charge. We don't have a lot of money, but he wants me to bail him out. If I do, we might have a hard time hiring an attorney. What do you recommend? What do you recommend we do, and what do you charge?
All right. So let's kind of break that down. When it comes to the question of do I pay for bail or do I hire an attorney, my response is always hire an attorney. It would be wonderful if you can do both from the get-go, but the majority of families out there simply can't. So why do you hire the attorney first? Well, temporary freedom is far less important than permanent freedom. So that immediate gratification of posting the bond and then all of a sudden your loved one is out of jail, that's great for the time being and oftentimes very necessary. He needs to work, he needs to help with the children, whatever it is. But if you drop the ball on the attorney portion of that, who knows, in 4 months, 6 months, 8 months down the road, he might be right back in jail, but maybe he might be in prison for an extended period of time. So was that really worth it? In hiring an attorney, you're doing two things. One is you are, assuming you get the right attorney, you're ensuring that anything and everything that can be done to protect your husband is going to be done. And if that means resolving the case with a dismissal, if that means resolving the case with lower charges and no jail and no prison, you've accomplished everything that you wanted. The hardship is, well, perhaps he's just been in custody in the process of doing that. probably the most important part is when you hire an attorney, one of the first things I find myself doing is filing a motion to modify release conditions. All too often, I get clients who come in with a bond of $100,000, $500,000, even $25,000. These excessive bonds. So we reanalyze why they got these bonds. We oftentimes find that there are mistakes, that there are misrepresentations, all sorts of different scenarios on why their bonds are so high. So we file this motion to modify release conditions saying, hey, judge, you issued this $500,000 bond, but what you don't understand about my client is he owns a home in this state. Therefore, he is not a flight risk. He's not just going to run and leave his $100,000, $200,000, $1 million home, to be seized. So that will tie him to the community. He's had a job for the last 10 years with the same company. He has children here. He has, different types of things that anchor him to the community. And by demonstrating that to the judge, judges are often persuaded and say, well, yeah, that makes me feel better that he's not just going to up and run to California or Mexico or wherever. So basically, by hiring the appropriate attorney, you've given yourself a better chance of reducing that bond, so then maybe you can afford both at the same time.
Okay, that makes a lot of sense. I have a pending drug sale court date. I don't think the public defender's office is helping me. When is it too late to hire an attorney?
The answer is it's only too late when a judge tells you that they won't let a new attorney on. And that happens, but it's pretty rare. Typically what we'll see is that happens the closer you get to a trial date. From personal experience, I'm very reluctant to take a case that is really far into the representation mode. I will have clients call me and they'll say, hey, look, I don't trust my public defender. I'm a week away from trial. Can you help me out? My common response is that I'm really reluctant to take these cases. And the only way that I would even consider it is if for some reason the judge continued your case for 3 or 4 months, then I would consider getting on. But it's difficult when you're that far in. You basically have to condense 5-6 months of work into whatever the time frame is, 1 month, 2 weeks, 1 week. And so when we really get to within that month time frame, I oftentimes politely say that I'm not going to accept the representation. But a lot of times I'll say that and they'll say, well, how much time do you need? To which I'll respond, if the judge can give me 3 months, if you can get that with your public defender, we can talk and I will likely get on the case. And a lot of times the judge will grant that request. So when's it too late? Well, it just depends on the judge and what we can work out. So no specific answer, but hopefully this points you in the right direction.
Okay, and the final question we have is, I have multiple drug charges. I'd like to hire an attorney. What payment terms do you offer?
All right, well, every drug case is totally different. You will find a lot of attorneys who do they'll be able to call out a price just from hearing what the charges are. I particularly don't do that. I don't think that's fair. You imagine 2 cases. Both of them are possession of marijuana for sale. Same charge, yet one of them talks about a truckload of 20 tons of marijuana coming across the border. The other one is a college student who sold a gram of marijuana to his friend. Those cases could not be further apart. So I can't really give you a specific price point for a drug sale charge or a distribution charge. It's such a fact-specific question that I would want to sit down and talk in more detail. And then we would work out the price, and then if needed, we would work out the payment arrangements, because we always do payment plans, so if that fits your budget. But because it's so fact-specific, I usually like to sit down with the client or the family members to understand that. And another thing is, part of the consultation, when it says that it's free consultation, that's not necessarily just with you. That's oftentimes with me going to the jail, speaking with whoever the representation is for, and getting an understanding of what the case is. That's part of the business model. Only after I understand, what the defendant's side of the story is, can I come back to you and say, here's what I believe the appropriate price is.
Okay, excellent. Well, if you have any other questions for Adam, all you need to do is post them to the comment section below. He's agreed to get back to you typically within a couple days with your answer. In addition, obviously, you can reach out to his office directly. Adam, thanks for your time.
Thanks, Ryan. And the biggest thing that with so many of these questions, they're very fact specific. You can always call me, 602-540-7887. That's my cell phone. So you're not getting a paralegal or a receptionist, you're getting me. And we can talk about the specifics of each question, each case, and I'll be able to give you more specific answers. And that's really what these consultations are about. So I look forward to hearing from you, and I hope the information was helpful.
Excellent. Thanks, Adam.